All right, good morning. Good morning again. I hate to interrupt the good conversation. I think that's one of the great things to have us all here today, but we've got a great and vibrant panel, and I want to get started. My name's John Pettit. I'm a managing attorney at Community Legal Aid, and I will be moderating this panel, and we're happy to talk about the rule of law. And so to start us off, I think the easiest would be to go down the list and have each of our panelists kind of introduce themselves and talk about what they do and why they agreed to serve on this panel. So starting out here, we can start with Kelly. Yeah,
Okay.
sure. Yeah, yes.
My name is Kelly Barr. I am the CFO of East Akron Neighborhood Development Corporation. I'm in my 19th year there, and we have a lot of housing, and we really want to promote homeownership and provide really good quality housing for people to live in. It's a huge deal for children to have a home that is stable and not having critters from outside crawling around or falling down around them. So it's very important to us. And I was first told I had to do the panel by my boss, who's in the next room. But once I embraced it, the panel, what they're doing is great. We need to get more word out about how we can work together because eviction isn't good for anybody, including landlords.
Great. Thanks, Kelly. Magistrate Angela Hardway.
Good morning. My name is Magistrate Angela Hardway. I've been with the Akron Municipal Court for a little over 3 years now. I am one of the 2 court-wide magistrates. I cover evictions and small claims. I also take part in traffic. I also assist all of the judges at our court. I happen to also be the mediation supervisor for our court and have been part of the implementation of the ODR project through the Supreme Court that has provided opportunity to landlords and tenants to try and negotiate out their issues before they have to come in front of one of us magistrates to end up with an eviction or not. The reason I am on this panel is, I'm one of the several magistrates in my court. They're on the front line and see the challenges and the issues that come along with filing an eviction and what the consequences of that are. So I felt very strongly. I've taken part in the eviction task force that Councilman Malik is part of, and with the eviction rates in our area, we feel, the Akron Municipal Court as a whole feels very strongly that if we can find ways to lower those numbers and keep people in their homes and keep landlords getting paid, that we have done a service to our community.
Good morning, everyone. I'm Shamus Malik with Akron City Council. I've been serving on council since January 2020, so I started and just a couple months later the world ended. But thankfully we're all back together here today. See a lot of familiar faces and friendly faces. Before that, I was an attorney with the city of Akron and worked on a lot of different things. But since being on council, I've tried to work a lot on housing issues along with a lot of my colleagues. Councilman Jeff Fusco is right here. And we on council have been trying to respond to housing issues, particularly during the pandemic, because we've seen what a burden, we already had such a high level of evictions, and it's become such an even greater burden during COVID. And have also participated in the eviction task force. And so, when asked, I will come. I agree that with what Kelly said, it's just so important that we raise awareness, have these discussions today, and then go out into the community and make sure that others understand the challenges and the sense of urgency that we all need around solutions.
Good morning, everybody. I'm Abigail Stout. I'm a managing attorney at the Legal Aid Society of Cleveland. I've been working there since 2006 and have primarily done housing work. And when I say housing, I mean landlord-tenant work. And when I say landlord-tenant work, I mean advocacy for tenants. So since I was a baby lawyer, I sort of recognized and saw as my time in housing law continued how impactful it was to have a lawyer by your side when you're being evicted. And I also saw how very few people were afforded an attorney by their side when they were evicted, and the outcomes were so radically different. And so being here in 2022 and knowing all of these great different tenant protections that benefit really everybody in our community, it's just astounding, and that's really largely why I'm here.
Good morning, everybody. I'm Sue Cummings, and I work for the Summit County Public Health Department. I am a healthy home specialist and a lead risk assessor, lead risk contractor, and I have worked in housing for 15 years. It's my passion. I deal with people every day facing eviction, and they're scared. They're afraid to complain. They don't want to leave names. So, we do everything we can to help them out. And Fair Housing, I've worked with Fair Housing for many, many years. I think they might have me on speed dial, and which is fine. So, I'm a passionate advocate for tenants.
Well, great. Well, thank you all for coming and joining the panel. This should be great. I have a number of questions that I'm going to lay out to the panelists and let them respond as they find appropriate. But also at the end, we're going to reserve a fair amount of time, hopefully, for Q&A, because we want to hear from you. And I've got Josh in the back that'll be going around with a microphone. And so we would ask that you save your questions until the end, but we anticipate having plenty of time for that. So I think to start out, maybe to sort of set the field, maybe the first question is, for those who have never gone through the eviction process, can you kind of walk us through that, the stages, the steps, and how quick that goes? And maybe Magistrate Hardaway, if you don't mind starting us off.
Thank you. I'm actually going to start a little bit before the filing of a complaint in my court, because there is a number of things that happen to a tenant by a landlord prior to that filing. There is going to be a notice that has been, if it's done properly, a notice that's been provided to the tenant if they are going to be evicted. At that time, it is giving that tenant an opportunity to rectify the situation, discuss it with their landlord if possible, and try to stay in their home based on what that notice is. Once that time has passed, the landlord can then file a complaint for eviction and possibly money damages with the court. At that time, they've now filed a legal action against the tenant to reclaim their property, and possibly for the damages, could be non-payment of rent, it could be damages to the property, that they're going to come to a hearing on. That hearing in our court is going to be scheduled anywhere from within 3 to 6 weeks, depending on the court schedule. So it moves very fast. The Ohio Revised Code allows for it to be what they call an expedited hearing. So it's not a long process, like maybe if you've gotten sued for a car accident, that could take years. This is not going to take years. This is going to be done in probably under two months. When that happens in our court, because of a pilot program from the Supreme Court of Ohio, we order mandatory online dispute resolution or mediation. That has been an administrative order that has been in place by our administrative judge since mid-2021. That is one of the last line opportunities to get the landlord and the tenant to speak and try to avoid going to the court hearing and ultimately ending up with some kind of decision on the record for either party. If that does not resolve, you're going to then come to our court. You're going to have a hearing that is going to only deal with the facts of the complaint that the landlord has filed. For example, if it's non-payment of rent, we're only going to discuss non-payment of rent because that is what is on that complaint. If it's termination of your tenancy, which means they've decided they just don't want you to live there any longer, we're going to discuss that. At the conclusion of that hearing, a decision is going to be made that a judge will ultimately sign off on. And if it is against the tenant, a writ is going to be issued. That writ is the notice that the landlord can purchase from our court to have the property tagged, giving the tenant a date that they have to move by. If that tenant does not move by that date, and that date, let me back up, that writ can be purchased anytime within 60 days of the granting of it from our court. If that writ is purchased and that property is tagged for what is called the eviction, that will happen within 7 to 10 days. If that tenant is not out of the property by that time, the landlord will be permitted with a bailiff and the sheriff to come and remove all of the property to the curb. At that point, we are out of it. Once that writ is issued, we're out of it unless there's what we call a second cause. That would be a separate issue as to the money damages for unpaid rent and damages to the property. That would be a hearing at a different time.
Great, thank you. Just a follow-up on that, maybe, Abigail, if you don't mind, can you tell us how that process differs for those tenants with an attorney versus those without? I realize that the legal process is the same, but in reality, often it's very different.
That's right. I'd be happy to talk about that. For a tenant who is not represented, the experience is so different than a tenant who's been represented. So that is where we start from. We asked Case Western Reserve University to do a study on what are the long-term impacts of eviction. And this was pre-pandemic, but I think probably the results are very similar to post-pandemic. And so starting from sort of what are the long-term impacts on a tenant who is evicted, and then turning to what the courtroom experience is like, what we see with those who have been evicted, and there's many, many studies out there, and this is just what our, this study in particular focused on in Cleveland, that there is really, they took away 5 major impacts. One is that those who are evicted tend to be more mobile. So if you've been evicted, you're less likely to stay for a long time in another unit in the future. You're more likely to move more often. That lends itself to instability. We see that in our schools and all kinds of other places. Second is that there's a high likelihood that when you've been evicted, you often end up moving to a less resourced neighborhood. And so there's fewer resources, the housing is in less quality shape. Third, if a family ends up heading to a shelter for some period of time, if there's an eviction, they end up staying in the shelter for a longer period of time than those who don't have an eviction on their record. Fourth, we see that there's higher absentee levels for those children who have been in homes that have been where there's been an eviction. This is especially impactful for kids who are in high school. The numbers are really different for those who've been through an eviction, especially for those who just never returned to school. And then the fifth long-term impact that we see is that for those families that have been evicted, they are less likely to have their children tested for lead, and when they are tested for lead, those test results come back for a higher level of lead in blood for more of those kids. And I think this is all sort of, if you think about what is happening for those families, you can understand why that's happening. So for a family who's being evicted, what we see is in Cleveland, it happens very, very quickly. The court process itself can be anywhere from 2 to 6 minutes, and that eviction has been granted. And now those evictions are taking place on Zoom, and so we don't have the data, but my thought is it probably happens a little quicker. And those families have to move usually within 10 days. They don't have a time. They are held, if they are unrepresented, to the same level of understanding the law as somebody who is represented. That magistrates will give maybe a little bit of extra help, but they are held to the same level as though they are lawyers, and which you can imagine is completely unfair. And so many people don't even actually go to their hearing. What they end up doing is just moving out or accepting that eviction on their record and moving out. We see that over 50% of tenants don't come to their hearing. The difference that we have seen in Cleveland, we passed a right to counsel in 2019. It was implemented in 2020. We've gone from 1% of tenants who are represented in court to 20%. The ordinance that we passed is only applicable to those who are at or below 100% of the poverty guidelines and who have at least one child in the household. And so for those folks, we're seeing really different outcomes. Most of them are able to move if they want to and have more time to move. Most of them are hooked up with rent assistance. Most of them are able to achieve the outcome that they're hoping for. So we've had really great results from that program. No.
Thank you. Anybody else want to add about the process?
I think just to add on the point that Abby was making about when someone has to go into a court and kind of defend whether they can stay in their home, but they aren't a lawyer, they don't know the magic words that you're supposed to use. It's a process that lacks like dignity and respect for that person, right? And so that's why this right to counsel program is so important, because it recognizes that, you know, this is a fundamental part of the process, is having a lawyer. That's why 90% of housing providers have a lawyer in this process. And we want to make sure that tenants do too, and that it also helps with communication. Often evictions happen because there's been a breakdown in communication between these two parties. And lawyers talking to lawyers can help perhaps smooth that over or engage in the mediation program a little bit better.
Great, thank you. So what does the eviction mean for both parties? We've talked a lot about what it means for the tenants, but how about the landlords? And maybe the other panelists too can talk about the immediate and long-term effects. But Kelly, from the landlord's perspective?
Sure. Again, I just want to say that we don't want to evict people. That's not what we got into the business of doing. It is a tool that we have to use sometimes that is required. We don't want to do it. However, having said that, I appreciate what you said about the getting before you file the 3-day notice, or I'm sorry, the eviction process. Communicate with your landlord. There are so many things that can happen beforehand that can stop an eviction, because the eviction will follow you forever. And while that does affect the tenant, it also affects the landlords, because many landlords say, I can't rent to people who have evictions on their records, right? And so now we're put in a position where we can't, based on policies. So it's so much, it affects us. It lowers our pool to choose from. It's costly for us. We go through the process of the eviction. While 2 months may seem like a very quick process for the tenant side, for the landlord side, that's money we're not getting in, and I do have a mortgage to pay every month. So it's costly, and then we have to turn the unit. Okay, so that's costly. We don't want that. We don't want to do that. It's so much better if you can come on the front end and say, hey, I can't make my rent this month, and we can work with you on it. We have payment agreements. We have started working more with legal aid with our tenants. In fact, in our Canton office, they're right next to us, and we've reached out to them a couple times to meet with our tenants at the same time before we start that process, so the tenant can understand what their options are. And then on top of that, I just lost my train of thought because I was so busy thinking about that. I'm so sorry about that. But the communication, the CARES Act, we were able to advocate for our tenants with their initiation. And through this system, we've got a lot of units, right? We have over 700 units. But for the last 2 years, we have been able to assist them with getting over $290,000 worth of rental assistance. That's a whole lot of money. That's a whole lot of people that didn't have to be displaced because they talked to us beforehand and we worked together as a team to keep them in there. So the long-term effects is financial, usually on the landlord side, but we don't want to see it, so let's work together on that.
Great, thank you. Sue, how about impact health-wise?
So it's interesting because what typically happens is people will call us 3 days before they're being evicted, and then they'll have a laundry list, and they'll always say, you have to get out here and tomorrow because I'm getting evicted, and I have now all these complaints. So it doesn't always work that way. We're busy. We do our best, but I wish tenants would call us prior so we could actually help them so they don't have to live in some dire circumstances. And I've also noticed recently a big uptick of anonymous complaints. So, and I don't know if this is a newer generation thing and they just don't want to deal with people, but they want to call about excessive mold in their house or on their ceilings caving in, but they don't want to give me a unit number. We can't do anything with that. Nor can we call them and say, you have to provide us some way of talking to you to see the problem, to document the problem. If there's a problem, we will write the order to the landlord. And another thing we get all the time is about mold calls. So there are no standards for mold. So when people call about mold, mold is an allergen. What we say to them is, while you might have mold, mold needs, 3 things, and you have to have a water source somewhere. Where is this water? Is something leaking? No. And usually when I go out, it's just a mildew around a window or a bathroom. So there's a lot of tenant education. But these tenants feel very marginalized. And here now another bureaucrat is saying, I'm sorry, there's not a lot I can do. So I'm very sympathetic I'm like, okay, well, I'm very sympathetic. They feel helpless. And that just is terrible. And some live in terrible conditions. But these landlords do the bare minimum repairs enough for us to. I have an apartment complex they have about 10 different buildings, and about 5 roofs every year collapse in on people. Now, I go out, they fix it, I abate it, and I just wait for the next one to fall in. That's not right, and it's subsidized housing. That is not right. But I don't know. I mean, I've tried everything. It's a HUD-owned property. I've tried everything. I've called God and everybody to say, we are putting people with children and ceilings collapsing, and this is okay. It's not okay. So I beat the drum as best as I can, and I call because I'm the squeaky wheel because it's not right. But if the landlord does the basic minor repairs, I am required to abate the order. So I understand why people are frustrated and unhappy.
Thank you. Others? Sure. Shamus?
Well, I guess I want to say to that point, that's one of the things that we've seen from the city is that we only have a handful of housing inspectors for the whole city. And these are folks who are, really dedicated to their work and are trying their best with a difficult system. But we're not able to be as proactive as we'd like to be. And so I'm sure you've seen some of the stories in the paper about conditions where, you walk into a home and the apartment's being heated by an oven and the kids are sitting just a couple feet away on a couch, right? And you press down on a floor that was recently renovated and water comes up out of the floor, right? And these are conditions that no one should be living in 2022, let alone in in our city. And so one of the things we were able to do this year is add budget for additional housing inspectors, 3 additional housing inspectors. So hopefully we can be more proactive. But we also need to look at our housing code to figure out, do we want to have a situation where, an order is made and then if a repair is made within 30 days, there's no fine? Well, maybe there should be a fine on the front end if it's an issue if it's the same issue with a roof that keeps falling in and in and in. It's not actually being resolved, but we don't have enough of a stick in our housing code. So that's another thing we need to look at.
And the quality of repairs.
Absolutely.
They have their Uncle Joe come, and it's going to fail in 2 weeks. And I'm like, well, call me back. I often think there should be a nuisance fine for properties that use, that we find issues at every single year. Every year I've been here.
Yep.
It's aggravating.
And no offense to anyone's Uncle Joe.
Yeah, no, yeah, politician, not.
Well, I'm glad you brought up about the conditions issues, because even though this is an eviction summit, certainly housing conditions that don't get addressed have an impact, right? There's a correlation with evictions. It is interesting, I know that in preparation for this, we ran some statistics, and we were talking about remedies for landlords and landlords having attorneys, and their remedy is to file evictions. In Akron Municipal Court, since January of 2020 through, it looks like this is about an 18-month snapshot through June of 2021, of the 2,700 eviction cases filed, 80% of those, 81%, had a landlord that was represented by an attorney. So, that's consistent kind of with what we heard, 80 to 90%. 11% of the tenants had an attorney, and so you see that vast discrepancy there. So my question leading up to that is, there is a legal pathway for landlords to go through the eviction process. What legal pathway exists for tenants to address their need? Sue?
Can I just say, because
Sure.
I didn't realize this years ago going into this, but we always advise tenants to escrow their rent. And so I was educated that when they do, because, a lot of my people will not follow through those steps, but I have had 4 or 5. Well, it turns out that at the end, they live in these conditions that aren't being controlled. Their rent's being escrowed. At the end, when they leave, the money goes to the landlord anyway. I'm like, so you live in these conditions, you pay your rent to the courts, but every penny goes to the landlord to make the repairs?
Yeah.
So what incentive do the tenants have to actually follow through the process? The landlord is going to get the money anyway. So why not? I don't know. It's just, I didn't realize they got every penny. Or I think there's ways that you can ask. Maybe that's.
We have had some rare cases where we do get the money back to the tenant, but again, that's usually if the tenant has counsel, and that doesn't
Correct.
happen a whole lot. And I don't have the figures for how many cases get escrowed, of the 9,800 or so that are eviction filings. And my guess is it's probably under 100 that
It
get.
is. It is.
Yeah, maybe a dozen, right? So along those lines, so even that escrow process or threatening to escrow is difficult, I think, for tenants, right? Because they can face repercussions, about that. Abby, do you want to talk about that?
Yeah, if you think about what Susan said about all of the calls that they're getting where people won't even leave their name because they're afraid of their landlords. Escrowing your rent is like that times 5 billion. Because what it means is you first, in order to do it, you have to first notify your landlord. They need to know that there's a repair issue that needs to be made. They get a reasonable amount of time to make it, which is generally 30 days, unless it's of an emergency nature, like no heat in the winter, no supply of water, those sort of big life basic needs. If the landlord does not make the repair in that time, then the tenant can start escrowing their rent. And that hits the landlords in their pockets, and so that usually can create some movement towards repair. And the money, under the the law, the money can go to the landlord specifically to make repairs. It also may go back to the tenant, or the court may order that the tenant have to pay less because the conditions of the unit don't merit that full amount of rent. And the tenant can also terminate the lease based on those conditions issues. But it is so underutilized because so many tenants are afraid of the connection to eviction. And so they would rather stay in those conditions than face the fact of having to move to another place that has equal or the same or worse conditions because of their need to move. And it goes to, the our long, our old housing stock, and a long time of not having super strong housing codes that require regular inspections and an ability to sort of hold those landlords accountable. That is not the responsibility of the tenant. That is the responsibility of some other entity.
And I think our landlords, some of them allow people into what I call the trap, where they only can pay their $100 perpetually every month short, or they pay it here. So it gives them immediate grounds to evict because they're never collecting the full rent. I hear that a lot,
You do have to be, you have to have paid, you have to be current in your rent in order to even start the escrow process.
And that they don't get receipts for their rent. I mean, there's some basic things as tenants that our renters still need to understand. You get a receipt, keep the receipt, take a picture of the receipt, have proof if you're handing over cash.
Magistrate, do you want to talk about sort of the challenges the court has with unrepresented folks and the escrow process?
Sure. A couple of things that has been mentioned from our experience in Akron. When the pandemic hit, we of course also went to virtual hearings. We were incredibly concerned with the attendance. Pre-pandemic, attendance for tenants was maybe 15%. So that meant that they did not attend, and you got to think of it in the fashion of they've got to get to the court, they've got some of them
Pay
is
to park.
transportation, they've got to get childcare. There's a lot of factors that got them to where they're being evicted in the first place. Social factors that I can't control, they just don't show up. Post-pandemic, and giving the opportunity for Zoom actually has increased our attendance by tenants to about 50%. We've actually seen an uptick, and we actually see a lot more attendance by tenants to present their own defenses. That gives us tools. If nobody shows up, we get one side of the story. If both people show up, we get both sides of the story, and we can then weigh both sides before we make a decision. Of course, we have to stay fair and impartial. And we're bound by the laws. We have the same laws everyone else has to follow, and we can only decide based on those laws. Legislative changes help us. City Council last year passed the pay to stay and income legislations. That has allowed us and has allowed tenants a way to, if the tenant can come up with the full amount of money, they don't get the eviction now. The landlord can't refuse it, which happens somewhat regularly. Once that 3 days filed, landlords refuse to take their money, but it has to be all of the money. So keep that in mind, it can't be half. So we've actually seen an increase in attendance, which has allowed more discussion. Additionally, when you're talking about the escrow process, and having an attorney, I believe, is vital. I can't tell you how many times the phone calls, here is legal aid's number. It may as well be on our recording. Because we can't answer the legal questions that tenants need to know about escrows. They need someone to tell them whether or not they are properly filing an escrow. we have seen an increase in escrows in the last 2 years go from what would have been maybe 12 or 15 for a year to 12 or 15 in 3 months. It has increased dramatically. We are hearing between 2 and 8 escrow hearings a month at the moment. Okay, that doesn't mean that they're correctly filed, but it does give the court the opportunity to require the individuals to now try to come to some agreement that they both can part ways and the damage isn't done. Okay, it is a tool that allows the court to get individuals out of a lease. One of the things that escrow does not do, and it goes to the point that the landlord gets the money, if the repairs are made, the landlord's entitled to the money that they've had escrowed, that rent, unless there is some showing that it wasn't habitable at the time. We can reduce the rent, and it is an avenue that the court can then terminate the lease agreement so that the tenant doesn't get sued for the remainder portion of the lease. So there's a lot of avenues that the escrow process gives to tenants, but it's got to be a properly filed escrow. If it's for things that are not considered impacting the habitability of the property, that's not escrow issues. That is violations of the lease, and that is a different type of filing. And unfortunately, without legal counsel, the layperson doesn't know that, and we can't educate them for that.
Just to sort of follow up a little bit on what Magistrate Hardway mentioned when she was speaking, she talked about source of income protection and pay to stay. What we have seen in the past couple of years is sort of a real momentum to add certain protections that you might think were just there anyways, but haven't been there. So we have to follow the state law, the Ohio state law, and then each ordinance has the opportunity to sort of add certain protections and certain ordinances that impact landlord and tenants. A couple of the trending ordinances in across the state have been, one is pay to stay. Ohio is one of 5 states in the United States that doesn't allow a tenant to rehabilitate their tenancy by paying all of the money that they owe their landlord prior to the eviction. After that 3-day notice is sent or is served, the landlord is entitled, under most circumstances, to proceed with that eviction, even if the tenant has all of the rent. And so many municipalities have responded to that sort of hole in our law by passing ordinances where tenants can pay in order to, and then the landlord must accept that rent and late fees, and if there's been an eviction filed, and the court filing fee. So basically, the idea is if the tenant can make the landlord whole, then the tenant has a right to stay. And with those ordinances, have a couple other tenant protections have been tacked on. One is the receipt issue. So many of those ordinances also include a protection where landlords are required to provide a receipt for rent, for security deposit, for utilities, anything else. And so that's something that we haven't had before. And then there's also been caps on late fees. Landlords can really, there are many leases that really afford a really high amount of late fees, and it just becomes impossible for a tenant to make rent and late fees. So some of these ordinances have a cap at either 5 to 8% of the total rent amount, or up to $25, something like that. And so those are really helpful for tenants. And then the other one is the source of income. This is where a landlord is not able to discriminate against a tenant by where the money that they're paying for their rent is coming from. So oftentimes there's, in rental advertisements, it says no Section 8, for example. This is the most common one. They'll say no Section 8. That landlord is saying they will not take a Section 8 voucher. They will not participate in that program. That means that somebody who can pay full rent and has the access to the, this great subsidy, so they should be able to rent anywhere in that municipality, can't actually rent in 50%, 80% of the places that they want to because that landlord won't accept Section 8. And this has been proven to be a proxy for race discrimination. So many jurisdictions are passing these source of income laws that say you can't do that. A landlord can't discriminate based on where your rent comes from. If it's Social Security, if it's rent assistance from one of these programs that have been implemented since the beginning of the pandemic, if it's Section 8. So those are just a couple of the emerging laws that have that are helping tenants and are really exciting to see.
And just to go off of that, I mean, it was really important that we pass both of those pieces of legislation last year, particularly because there were situations where landlords were saying, I don't want to accept CARES Act money or rental assistance money. And really it was a pretext. They didn't want that specific tenant there anymore. And so they were using this as a pretext. And but it also goes to Section 8, and this has happened for decades. And so now you can no longer have that no Section 8 in your advertisement in the Beacon Journal. And it really speaks to this idea of a stigma that people who are Section 8 renters are somehow less than other renters. And the reality is that if you have the money to pay, it shouldn't matter the circumstances by which you have that money. What matters is that you're able to do that every month. And so that was really critical. The other piece, pay to stay, kind of comes in on the back end, right? If someone is able to make the landlord completely whole before an eviction is ordered, what is the point in putting them out on the street, especially during a pandemic, right? And so those are two common sense things that we took from Columbus, we took from Toledo. I was really proud. We beat Cleveland to it. Cleveland is considering it now. But there are things Cleveland is way ahead of us on, right? So the Right to Counsel program that Abby mentioned, right? They've been doing this for over a year, and the results that they're seeing are incredible, right? The amount of money that's being saved by social service agencies that don't have to help place people who are homeless, the amount of time that kids who are homeless might not be able to make it to school and now are now able to make it to school, right? And just having a lawyer means that you might be able to negotiate a move out so that you have an extra month to move out, or you have an extra 2 weeks, and you're able to find a place so you don't end up homeless. And the housing is so related to all the other issues we're dealing with, right? If a kid is not sure where they're going to live at the end of the night, or where they're going to put their head at the end of the day, they're much more likely to be involved in things related to trauma like youth violence. They're much more, have a much harder time with educational attainment. And so I'm really hoping this is something we can pursue through the ARPA money that we have as a city, as a pilot program. In Cleveland, it's with Legal Aid and United Way. There's a partnership. And so that's something we could do here with our Legal Aid and with our United Way in our city of Akron. So, and then there's, and not to step on your toes, Angela, but all of the work that the judges are doing in the municipal court with this mediation program. And so we can help expand that mediation program as well, right? And make sure they have the resources and they have the staff and the capacity to really bridge those communication gaps. So there's a number of things that we can do. We really just need a greater sense of urgency around doing them.
Just
Sure.
real quickly, I wanted to ask, these are all great things, and luckily, E&C, we have Section 8 tenants. We take money to make people, because our goal is to have people in there. But once it's filed, it's on their record forever.
Yeah.
So if I have a tenant that makes me whole and I want to say, hey, I would like for this to get off their record, is there anything in place like that we can do to help out?
I'll let Angela speak to it in more in depth, but sealing of records has been a big topic of interest over the last few years. And again, I'll let you speak to the specifics, but it is a really significant challenge because often it's hard to rent if there's several evictions or even eviction filings that were not ultimately granted on someone's record. That's something I know the court has discussed, so I don't want to step on your toes.
We have. No, that's okay. That's okay. I'm glad I took notes. So in 2019, and it actually went into effect in, I believe, February of 2020, we had proposed in our local rules something called Rule 39. That proposal had tried to create an expungement or a sealing of eviction records. It was very proactive, for the lack of a better way of putting it. There are not a lot of municipalities in the state of Ohio that allows it. What you've seen through the pandemic is suddenly there's been more movement toward allowing for this, because there were so many evictions that were related to just the pandemic that your pool of tenants just changed dramatically. People are penalized because the pandemic affected them, not necessarily the reason that evictions are there for the habitual individuals who don't pay their rent. And when we proposed it, our rules were going to be that there were extenuating circumstances, and there had to be 3 years past since the judgment was rendered, or that the judgment was satisfied, and that there had been no more evictions on that person's record. And that wasn't just in our municipality, it was all the municipalities. So there was a way for landlords to get monies that were back owed, as well as get the ceilings, so that people were not prohibited from reasonable housing. Unfortunately, at the time, the landlord bar was extremely vocal. There were many concerns among the judiciary across the state that we had to table that. Let's move forward 2 years now. What you're seeing not only is more willingness from both sides to actually see this happen now, which we're happy to hear. You also have Senate Bill 158 through our Ohio legislature. Senate Bill 158 has actually been now announced as a bipartisan bill. So you have both sides agreeing to wanting an eviction expungement or sealing process. That is certainly, it is currently sitting in the Senate. They have not had meetings on it yet, but that bill, very similar to the Akron Municipal Court Ordinance local rule that we had proposed, was a 3-year. There would be 3 years of no evictions or judgments, but it also allows, it's actually a little bit more liberal than our bill was, our local rule was going to be, because it actually indicates that the judiciary can find, due to interest of justice or reasonable predictor of future tenant behavior, if we believe that the tenant isn't going to get evicted in the future, regardless of what the landlord says, we can seal their record. There isn't any movement in that bill to make landlords whole. We were attempting to make it fair and equitable across the board to both landlords and tenants. So I think that I know my judges are willing to consider reviewing our sealing record again, and hear some positive feedback from it. But you've got a Senate bill at the moment sitting out there, so this may go statewide.
Mm-hmm. Abby, any experience in Cleveland with that?
Yeah, we actually have a local rule. I think it sounds very similar to the one that was proposed up here. It was adopted in 2019 and has a lot of the similar aspects, the similar terms. So there are, under Ohio law, there are a few routes to having a record sealed. There's the inherent authority of the court to seal a record, and that's like a weighing of, is there a public interest in that record being available to the public, or is it the detriment to this person more burdensome than that public interest? There's Rule 45, which also, I'm not going to bore you with the legal theory behind that, but that's another route. And then this adoption of rules. But as you can imagine, and with the adoption of rules, often many courts have provided the documentation or the form that a tenant needs to to produce or to file with the court in order for it to be done. So they do make it easy for, the whole purpose is to let this happen. And then Franklin County actually has, their clerk of courts has they don't make accessible to the public via their electronic online docket system any eviction record over 3 years. You can still try to go look it up at the clerk's office, but it makes it far less accessible. But you can imagine that even that aspect of tenant protection is hard for tenants to do if they don't know how to do it. And again, legal representation, it's often a part of how we settle a case. We also say, do you agree to seal the record to the other side? And that's one of the critical parts of settling a case that helps our clients.
Great.
Keep in mind, one of the things that when you hear the difference between Cleveland and Akron, Cleveland has a housing court that is codified.
Yeah.
So they have different authorities that they're able to implement because they have been given the authority through the state legislature. They're only one of two in the state of Ohio at this time. They're very costly. The housing courts are very costly to the community. Our court has recently, under the direction of the administrative judge, Judge Cable, we have proposed what we call a housing program. And that is not going to be a codified housing court, but it is going to be a program that is going to allow us to work closely with City Council and the City of Akron to maybe get some legislation in our Akron city codes, like expungement and sealing, that would then be in effect, that it isn't just a local rule that is going to be scrutinized based on the Ohio law, because every one of our local rules, if it is a conflict with the state of Ohio or a state of law, it can't go into effect too. So there's some question on that, but if it becomes a city ordinance, that's a whole different ballgame for us. So our housing court, in addition to providing some services to maybe avoid the eviction and get landlords paid as well as keep tenants in their home, by offering some more information that maybe a tenant didn't have available, as well as some staff that will assist through the eviction process in a neutral way. We feel that working with the city council to maybe update some of the municipal codes that will reflect better protections to both landlords and tenants, because sometimes it feels like it's very landlord-sided to the tenants, and the tenants and the landlords feel like it's tenant-sided. It just depends on how that day went for you guys. We want there to be city ordinance in place that will give the protections. And that I will leave to Mr. Malik now.
There you go, just putting the ball in my court. I think the important point from there is that it's so important that we all row in the same direction when it comes to the Akron Municipal Court, Akron City Council, the mayor's office. We all have a role to play, whether it's legislating, whether it's implementing and enforcing our housing code, whether it's actually managing the process of housing court, right? And, Magistrate Hardaway mentioned how expensive a housing court can be, and I'm not going to downplay that. But what I am going to say is, how expensive is it not to do that? Right? Because when we say we have the highest eviction rate in the state of Ohio, what is that churn doing to landlords and tenants, right? It's not like a landlord enjoys the housing, the municipal court housing experience, I think, tremendously, right? And it's a churn to always find new tenants. It's a churn to always make repairs and things like that. And I think we want a more stable system, a system that works for everyone. And that might create some pressure points here and there for folks if we're enforcing housing conditions a little bit stronger, or if we're requiring a little bit more mediation. But I think overall it leads to a better picture at the end of the day for everyone. We have more than half of the households in our city rent, right? This has tremendous impacts to people in terms of their health, their transportation, their education, their safety.
I know that they're noting that it's the Q&A session, but I wanted to make one point with regards to the housing program. One of the things that our housing program that we have put in is actually assistance for the landlords to make their properties better. Judge Walker in our court is going to head that part, especially for landlords or owner-occupied, because that is part of our housing issue, is owner-occupied properties who are not able to make the repairs that are necessary. And they're now getting fined criminally. But Judge Walker, with the assistance of this program, will be able to put landlords who are going to be part of the evictions or can barely make the roof repairs in touch with the right people in our community to get the assistance, because there's assistance for landlords as well to keep their properties in check. There isn't a reason, if the landlords are also seeking out the assistance that we have in our community, that they can't get the necessary repairs as well. We, just as the judiciary, can't be the social service part. But we can, through the program that we have suggested, through mediation and through a fair and equitable system, can at least give everyone the tools to try to get the information they need, so that if they have to come in front of us, they've exhausted all of their remedies before they have me make a decision.
Well, this is great. I do want to open it up to the audience. If you have a question, Josh is back there. If you would raise your hand, and Josh can get the microphone to you.
Thank you. Hi, my name's Shayna Carino, Direct Service Provider for Project Rise, Akron Public Schools. I am coming from the angle of how to advise families who are in this situation. One of the gaps I'm hearing here is what does the escrow process look, or what pathways do families have when they are living in conditions they don't feel like the lease is being met, they don't feel like the conditions of the home are being met, if they're in a subsidized program, a housing choice voucher or HUD housing, and they're not the ones physically paying the rent?
That's a great question.
If they're in the Housing Choice Voucher Program, we would recommend that they inform their landlord of those issues, of whatever the conditions issues are, and then they also contact the Housing Authority to come out and do an inspection. They should do an inspection, and based on sort of the level of emergency that housing condition is, it could be a few weeks or it could be in a couple of days. Then if that inspection shows that there are repairs that need to be made, they will inform the landlord and give them a certain period of time to make those repairs, and then they will come back out to do an inspection. If it's a HUD building that is like a Section 8 project base, so the subsidy is with the building, not with the tenant, they should call the HUD complaint line. There is somebody on the other side, and that is the best way for HUD to know that there's a problem. So they should, go through whatever the pathway is in their building to try to get a work order in. But if it's not met, then they should go to HUD and make a complaint, and always recommend that they contact the local legal aid because they may be able to get some help through them.
Hi, my name is Jordan Collar. I'm a staff attorney with the Legal Aid Society of Greater Cincinnati. And so we are quite behind you all in ordinances and enforcement of ordinances. And so this question, I sort of have a two-part question for Magistrate Hardway and Abby. The first is, so we passed a pay-to-stay ordinance in September, and our local courts announced that they would not be enforcing it because they believe it conflicts with Ohio state law. And so for Magistrate Hardway, if your court did any analysis of that at the time, or if you've seen any legal challenges to that, that's sort of the first part of the question.
We have not. We have not seen any challenges to it. I have not, we have not seen that many actual individuals coming with all the money. It is a lot of it. But what our court does is if the individual comes to the court with the money that they got on a letter or however notification, and they say, here is all that money, we will hold it for the landlord can pick it up, and they have to dismiss their case or we're gonna deny it. We have not seen a challenge come through, we're in the 9th district. I have not had an appeal yet for the ones that have had to. As long as evidence is presented to us at the hearing, that an offer was made that, of all of the money that was owed, and the late fees are within the allowed amounts, because there are many leases that do not have proper, late fees, so we can reduce those. And they have, shown credible evidence that they in fact have attempted to pay it, and the landlord has said no, their case is going to get denied.
Have there been any legal challenges in Cleveland?
There's, Cleveland does not have a pay-to-stay ordinance, but there is a number of municipalities throughout Cuyahoga County that do. And so what I've seen with the pay-to-stay ordinances, there's sort of two camps that they fall in. One camp of how they are drafted is that they still allow the court to have discretion. It's drafted as an affirmative defense. So if the tenant comes to court with all the money, they can affirmatively say, which is just sort of codifying a defense that we already had, which was the equity defense, but it does definitely strengthen it. The other sort of form of that ordinance is where the court really doesn't have discretion. The ordinances are framed in such a way that if the tenant tenders the rent, the landlord shall take it and inform the court, and the court shall dismiss the case. So clearly there is a difference in how those operate. And so we've had a couple of challenges in Cleveland Heights where that have been difficult because we've had like the rent assistance organization testify as a witness that they have the money, they've offered it. We had actually one of the great advocates in this this area as an expert talk about how this is supposed to work, and it still was denied, or just the eviction was granted. So, and that actually the eviction wasn't granted because we ended up going out of the court and making a settlement. But anyways, we are sort of waiting for the right case to challenge that particular ruling. And so these are really new laws, and so there isn't a whole lot of case law yet, but I think we will start seeing it, as time passes. And just to Cincinnati, you guys have had a source of income discrimination law on the books since the 90s.
Oh, don't get me started.
So, so that's great. I just want to say.
Yeah, well, it's not. It has never been enforced. So.
Well, that is an issue.
Yeah. But the second part of my question is, have you seen any cases where I foresee a circumstance where the tenant, between the time they receive the notice and the complaint is filed, they offer to pay all past due rent and late fees? Landlord denies, it goes to court, and then the court says, well, now you have to also tender court costs. And in that situation, it seems like the tenant shouldn't be required to tender court costs because, they tried to pay before the eviction filing. Has that situation presented itself for either of you yet?
That's what I would argue.
Yeah, I just wasn't
Yeah.
sure if the court has seen that
I
situation.
don't think we've seen it.
I think that's going to be to the discretion of the magistrate that's going to hear that case.
Yeah.
Okay, thank you.
Thank you. So far, great questions. I think we have several more here.
I do just quickly want to go back to your question. The rent escrow process is also an option for people who are in subsidized housing.
Yeah.
They are not left out of that. Even if someone pays like $10 as their portion, they can still escrow that $10, $5, whatever it is. And I do believe like the issue of if your rent is zero has come up, like how do you access that rent escrow? And in fact, it was just like on a listserv in the last few days. So I think that is still sort of like an open question of how to use it if your rent amount is zero. Yeah.
Hi, my name is Deborah Holman, and I have a comment, but also a question to the panel at large. When it comes, I just recently went through the process of escrowing my rent. And then when it comes to landlords, there needs to be, the question to the panel is, what is the support that you have for tenants in situations where it comes to eviction, escrow, challenging the landlord with repairs? Because it took me a whole year. And it actually got done last month. Even though I escrowed my rent in November, the court ruled in my favor, returned my money. The landlord still would not do what needed to be done. And it was 2 years about the balcony, but a year about my apartment. And I am disabled with health issues. I called every number, every agency I could think of in the city of Akron. And it literally left me in tears because nobody would help. And it got to the point that when I got to the courts, because I had the documentation, I believe, where I began to make notes about what happened, who I called, the time, the date, and all that, and I had a calendar. And that's actually how I met Attorney Petit. He asked me, was I a lawyer in a previous life? No, but I had been through so much as a tenant trying to make the landlords accountable for the living conditions. And so my question to the panel is, what preventive measures can you come up with to support tenants, whether it's eviction, whether it's repairs, because tenants need support. And the landlord, the law used to be in favor of the landlord, is now in favor of the tenant if you take them to court. So when you go in their pocket, it does get their attention, but I found out in the long process, threatening with the media make them move a little faster. Because I used Prosecutor Walsh calendar. I called all those numbers. I called the street card. I mean, I literally called everyone I could think of in Akron. And I heard the phrase, "I'm so sorry," that I don't ever want to hear that phrase ever again in life. But tenants need someone to not just say, okay, this is not right, but actually to make these people accountable for not making the repairs in a timely manner. So what support are you willing to put out there to help the tenants so that it doesn't take a whole year or longer to get changes made that are necessary for our health as well as safety?
Absolutely. And when you were talking, the first thing that I wanted to say is because people call me on this council cell phone and they tell me stories like this. And the first thing I say is the thing that you don't want to hear, right? Just that I'm so sorry, because no one should have to go through a system like this, right? And we can all recount lots of stories of folks who are playing by every rule, who are calling all the numbers, who are doing all the things that are right. And the bureaucracy that we have just is failing people, right? And there is no easy solution, and I'll leave it to my esteemed colleagues. I'm sure they have ideas. But one of the things that we can do is make sure that at every level of the system that we're trying to really listen, right? Listen and slow down and to really hear what people are saying and to go back and fix the system for the next person, right? Because, for example, when someone calls to make a housing complaint, right, they might call 311, but if they don't give all of the correct information, that's not necessarily going to be followed up on, right? And it might not be followed up on even in a timely fashion. it took years of us saying, of folks, advocates in the community saying we don't have enough housing inspectors to get 3 more housing inspectors. But when I said that, it's not the end of the line. Those people haven't been trained. Those people haven't been hired, right? And so, it is unbelievably frustrating. And I know that everyone here has experienced that frustration even more than me.
I'm sorry. I was one of the ones that said I'm sorry to Deborah, and she's in one of the unique things we have in Summit County is when we merged, the 3 health departments here merged about 12 years ago, and that was Summit County, Akron, and Barberton. But certain things did not come to Summit County Public Health, such as housing. They do have their own housing division. So we often have people that reside in the city of Akron that call us. And we are very limited to what we can do. I mean, I think I was out a couple times at Deborah's house because I felt really bad for her and trying to figure out how can I best support her in this role. How many phone calls though? I mean, she had to call me 5-6 times. So it's very frustrating, and and the tenants don't often understand there's 2 different authorities working in this county regarding housing.
I would first like to say, Deborah, I totally salute you in your tenacity and the effort that you made to get what you needed done. And I think we should just give you a round of applause. I mean, you have done what so many people want to do, and you got eventually what you needed. But I think what you brought to us today is the voice of all of those people, and you have explained to this group here why it doesn't ever get done, why the escrow process doesn't get done, why it is so difficult to get a tenant to try to get the repairs made, the conditions fixed, because it is a nightmare. It is so much work. You probably spent hours and hours and hours of your life trying to do that. And I think we can agree that that is wrong. And so, Councilman Malik, I'm going to actually put it back in your lap that it sounds like we need to have some changes in our ordinances and our laws in order to support our community in making sure that they're living in healthy, safe, stable housing.
Absolutely.
Yeah.
I agree with you. And I feel that sense of urgency. I think a lot of people in the community do. I know the judges and my colleagues here who do as well, but really there are so many issues, and I know in the coming weeks council is actually, what's the date, May 24th? April 24th. We're going to be holding a town hall later on in the month, and we're going to have a series of them, and then we're going to have a council task force that's going to be working on some of these issues. But there are so many examples of things that do need to be changed. We have a county rental registry and a city rental registry for the same things. I mean, if I was a housing provider, I'd be frustrated. But if I was the judges, I would also be frustrated because which set of registration are you supposed to follow, right? And that's, again, we shouldn't have to explain to people, well, there are 2 different sets of authorities, right? It doesn't matter, right? It's not efficient for anyone. So there are so many changes that we need to make, and I'm not sitting here and asking anyone to be okay with the status quo. Everyone needs to be pushing, and everyone has a role to play, right? It's not just the folks who are in leadership positions, but we have 190,000 people in this community. Everyone needs to be pushing for changes. Absolutely.
Well, one thing too that we didn't get to talk about solutions and things to do is tenants have been getting together to form tenant unions, and I wanted to congratulate Ms. Holman. She also not only did a great job with basically doing all the work. I came along for the ride in the court case, but she also is a tenant union president for her apartment complex, and just.
That's working with us to correct the problems, but it was a struggle.
Yes.
And it was very, very tiring and emotional to go through that. So I think accountability is the biggest word. Making the landlords accountable, and as well as maybe considering together where you can make one phone call and get the help that you need, or at least, and then also with the city of Akron, holding them accountable, because it's like, when I contacted them, they said, okay, we will notify them and we'll let them know they have so many days to make these corrections. And then when I asked, okay, what happens after you do that so many times? And it's like, I was told, they're just gonna keep asking them. And I'm saying, okay, they've shown you like 3 times, 45 days, that they're not gonna do what needs to be done. What do you do? What's the next step? And it appeared to me like nobody wanted to find them or whatever the next procedure is. It's like, so if you're not holding them or making them accountable, then they're gonna keep the landlords, that's how they hold the tenant down. And then if you don't want to comply with what they want, then they want to go with the eviction. But I think I had them asking themselves the question, when did I move this crazy person in here? Because I was ready to fight even with the eviction. You're not getting my money anymore and not making the things or the changes. And I mainly did it even though agency was saying you can't do that. I, as a previous preschool teacher, can't is not a word that I taught my children. Can't is not a word. Because it's the 2 words. Can, you can do anything you set out to do. And that was one thing I proved to Mr. Curry, the Fair Housing Advocate. I said I did it. He's like, you did? I'm like, yes, I did it. I escrowed my money. The court gave me my money back. And he was like, wow, I need a copy of that. I'm like, why? You didn't help me. And to show other people that it can be done. I used to advocate for seniors prior to becoming a senior. I had no idea that when I became a senior, I'd be going through all of this. But I did it mostly to show people that you can do it. You have to, my mom taught me, teach people how to treat you. And if they're not treating us right, then we have to make them, and it starts with us. And so at White Pond Villa, we've been on the news a lot, but we are now getting things accomplished and things achieved. But it's not even, it's just the beginning, because there are so many other apartment places here in Akron where people are in worse conditions than we are. And someone needs to be made accountable.
Well, thank you, Ms. Holman, and really I want to congratulate everybody for being here, because even though we've identified there are problems, we've also identified some solutions, and one of the greatest things that we have here in Akron is a sense of community and people coming together and wanting to get things done. And we at Legal Aid cover 8 counties, so we see different areas, and Akron and Summit County really is a testament of just having this event here today of the willingness of the community to come together. So I want to thank all the panelists. A great job. Thank our audience, and can we have a round of applause for our speakers? And so I'm not negligent here. I think the next session they want us in there by 10:40. And that is starting at 10:45. So I apologize that we didn't get to the rest of the questions, but thank you very much.